Good afternoon. I know we're slightly later than usual. That is obviously because of today's speakers. I hope you've all had a pleasant break over Christmas and the New Year, despite all the unfortunate circumstances surrounding the word we won't use and the different stages of lockdown. But at least the UK is functioning after Brexit, and we are still at the top of our game, exporting different variants of COVID around the world. So there you go. Actually, we here at Barton Legal are very optimistic about the year ahead. We've got some absolutely fantastic webinars scheduled in the coming months, and we've got more incredible speakers in the works. Today, we're really privileged to have two extremely qualified and knowledgeable speakers, making this webinar an invaluable learning opportunity, as well as what I hope to be an enjoyable experience for you all. So just to remind you, there are some housekeeping points. We use Zoom, but it's the meeting function. So that means if you want, everybody can see you and your name picture. So you've had a bit of networking, the same will apply at the end. Your video and audio is on. If you can make sure your audio is on mute once Bill and Claudia speak, that would be much appreciated. If you see anybody in the chat, obviously you can send them a message. And if there's someone you don't manage to connect to but would like to, just message me, email me, and I'll make sure we try and get you in touch with them. It's important, that's important, because this isn't just about a webinar. To me, it's an opportunity to do more than just learning, to network, share experiences, and of course, we also welcome any feedback. For anybody who doesn't know me, obviously I should have told you at the beginning, my name is Bill, and I'm one of the directors at Barton Legal. We specialise in construction, and I have the lucky job of hosting these webinars when I'm not speaking. Obviously, it's my job to make sure everything runs smoothly. So if anyone has any problems, put it in the chat, and obviously I'll get someone else to fix it. Before we begin, I'm really pleased to welcome people from so many different countries. There are some countries that aren't very welcoming to this sort of webinar and Zoom. One is Iran. So I'm not sure if I should name him, so I'm just going to call him Jay, but I know that he's going to go onto the website because he's emailed and download the video, so hi to him. I think that Megan Kelly from Construction News is on. Brilliant, lovely to have you on. I hope this webinar brightens up your day. And again, if you would like introductions to anybody who's on the webinar, let me know and I'll make sure that's done. And for the rest of you, Construction News, strongly recommend you subscribe as we do. It has a lot of interesting content and it's very insightful. As you know, we've got two guest speakers today. We've got Bill Howard, the president of FIDIC, who's going to be speaking on, surprisingly, FIDIC, as well as recent and upcoming developments for 2021. And also Claudia Solomon, who's the incoming ICC International Court of Arbitration President. There's a mouthful for you. Who's going to give her bespoke overview of ICC arbitration, in addition to discussing its global reach. And they're each going to speak, and then afterwards, we're going to have sort of a question session. I'll raise some questions. They're going to talk a bit more about their sort of personal journey to this point, but that's the point where all of you can ask questions. But before I do the actual introductions, a quick mention that we do have upcoming webinars every month, the details of which you can find either on LinkedIn. Sounds very much like an advert, doesn't it? But you can also get them on our website. You can also find the past webinars. We now have a YouTube channel, yes indeed, called Barton Legal. Or as I say, just go onto the website and they're all downloadable. In March, the webinar is called The Long View, What Parties to Long-Term Project Contracts Need to Know About Disputes and Avoiding Them. And that's with Gordon Nardell QC and Sue Kim of HKA. And again, that's on the 25th of March at 11 o'clock. So after my long-winded ramble, I'm delighted to present you with the first speaker, Bill Howard. Mr. Bill Howard, of course, really should address him, is from Massachusetts. Normally, I don't like sharing my name. I like to be the only Bill. But given that Bill is clearly much more important than me, I will let it slide on this occasion. Bill is the president-elect of the International Federation of Consulting Engineers, FIDIC, and a strategic advisor to the executive leadership team of the global engineering and construction firm CDM Smith. He served the firm for over 27 years and has had numerous leadership roles, most notably Executive Vice President for 14 years up to 2014. In the field of engineering, Bill has held numerous noteworthy positions, councils and committees relating to engineering across the USA. And he served as chairman of the American Council of Engineering Companies, as well as chairing the Council's International Committee. He's held board positions at the Northeastern University of Massachusetts, as well as receiving multiple alumni awards, which of course, that just makes him stand out. I've never received anything. He's obviously, you don't get to be president of FIDIC without being an expert on it, and that's just what Bill is. He was the primary author of the 2000 FIDIC State of the World Report on Water Challenge, and as a member of FIDIC's Board of Directors, which he's now chairman, he's advised the organisation's Contracts Committee in producing the 2017 Conditions of Contract for Construction, Design, Build and Transfer Projects. So there you are, another long mouthful. I'm also going to introduce Claudia now, because once Bill has finished, he's going to pass straight over to Claudia, so you get a good chunk of time without listening to me. So Claudia Solomon is the incoming president of Icc International Court of Arbitration and a shatterer of glass ceilings, as she is to become the first ever female president in the institution's 100-year history. Claudia was formerly partner and global co-chair of the Latham and Watkins International Arbitration Practice, where she engaged in many complex and high-value cases and disputes. She is fellow of the Chartered Institute of Arbitrators and has acted as arbitrator and counsel in arbitrations all over the world. Now, however, a new branch of her life, and she's dictating her own path by opening her firm Salomon Arbitration, starting this year with offices in New York and Paris. Due to her extensive expertise, she's a sought-after speaker and writer on international arbitration, and is co-editor of Choice of Venue in International Arbitration. Claudia's dedication to her work, as well as her sound judgment and effective case management, have time and again proven her to be a powerhouse in the world of international arbitration. And that is a quote that I found in many places. So I will now, I promise, shut up for a good length of time. Your jobs are to put where you're from in the chat function. If you could also tell us which form of FIDIC contract you've most used. If you could tell us if you've dealt with arbitration and particularly ICC, and put questions in the chat function, and we'll keep them going, and we will capture those at the end. So I'm now going to hand over to Bill, and thank you very much. Bill, you're muted.
Thank you. As I started to mention, something is going on. I've done Zoom quite a bit, and the screen keeps coming in and out. So hopefully we'll get.
Yeah, I think it might be me.
Okay.
I'm just turning my.
Okay. Well, great. Let me start. First of all, to pick up on the Robert Moses comment, Bill. Another great book on construction is written by David McCullough on the building of the Brooklyn Bridge. David McCullough is a great fan of engineers and construction folks. And even though that Brooklyn Bridge was built right after our Civil War, A lot of the same things apply that he was pointing out in public works construction. So that's a great book, a little bit thinner than the one you're reading, Bill. But at any rate, Rachel, thank you for running the slides. And on behalf of the FIDIC Board of Directors and our Chief Executive Officer, Nelson Ogenshaken, and our many, many volunteers and the Secretariat, I really appreciate being here today. Next slide, Rachel. While FIDIC is involved in many, many activities, today I thought you would be most interested in hearing a little bit about FIDIC, a very little bit, and then 4 activities, the ones that are shown here, which I think of most interest to the audience. So Rachel, if you could get the next slide up. FIDIC was founded in 1913. We're headquartered in Geneva. We strive to be the voice of the consulting engineering firms practicing globally. We represent over 40,000 professional engineering firms from 100 countries, and we emphasize and advocate for sustainability, quality, and integrity in everything we do. And Rachel, next slide, Rachel. There's a lot going on in FIDIC, and that is an understatement. And I encourage all of you who are interested to peruse our website and take a look at our annual report. It's a quick read, but it discusses just about everything that we're involved in. So it'll give you a good flavor of all the activities that FIDIC is involved in. So next slide, Rachel. Now into the meat of the presentation. FIDIC conditions of contract are highly valued around the world. When leaders of global firms are asked about the importance of FIDIC to the global infrastructure community, FIDIC conditions of contract are almost always mentioned first. Rachel, next slide, please. We believe that the core value proposition of FIDIC contracts is that we strive to produce documents which are fair to everyone and which balance risk. Specifically, we develop documents which assign risk to the party who has the best opportunity to manage the risk. Some of this risk balancing is, of course, dependent on the delivery system chosen for a particular project. For example, by definition, the FIDIC design build conditions of contract, i.e. the yellow book, assigns more risk to the design builder since they are assigned more control over the many risk factors of a project. And this is a huge point with our conditions of contract. Next slide, Rachel, please. FIDIC conditions of contract have been produced for all phases of projects, ranging from services or engineering kind of work through construction and operation and startup. We also produce, down in the lower left-hand corner, documents related to procurement and best practices, which are critical to a successful project. Finally, we work with some of our larger users of FIDIC contracts to produce harmonized conditions of contract for their specific use. Next slide, Rachel. While we at FIDIC understand that owners have preferences and sometimes legal requirements, which they need to put into particular conditions to suit their specific needs. But over the years, we've observed problems that have arisen when the FIDIC conditions of contract are substantially modified. In such cases, the contract in reality might not even be considered a FIDIC contract. To address this issue, we recently issued guidance to users of our conditions of contract and have called them golden principles. The essence of them is shown on the slide. The duties, rights, obligations, roles, responsibilities of all contract participants must be as generally implied in our conditions. The particular conditions should be clear and unambiguous. They must not change the balance of risk and reward. Time periods should be reasonable. And Golden Principle 5, which is a very huge one, is unless there is a conflict with the governing law of the contract, all formal disputes must be referred to a dispute avoidance or adjudication board or a dispute adjudication board if applicable for a provisionally binding decision as a condition precedent to arbitration. And that is a major factor. So those are golden principles. There's a lot more on our website that discusses each one of them. And I'm sure many of you listening in today would be very interested in reading through them. A number of you probably already have. Next slide, please, Rachel. Due to the demand for general conditions of contracts around the world, they've been translated into Arabic, French, Spanish, Portuguese, Chinese, and other languages. And I should note that the English version controls in the event of a conflict. Next slide, Rachel. Credentialing is also a very important FIDIC initiative and ties to what a lot of you, I think, are interested in today. We at FIDIC, next slide. We at FIDIC have been strengthening our certification programs consistent with our emphasis on quality in everything we do. Currently, we have programs in place to certify adjudicators, trainers, consulting engineers, future leaders, and contract managers. The demand for arbitrators and trainers has been increasing, and it is becoming even more important to have arbitrators and trainers who are well qualified for the service. The FIDIC Certified Consulting Engineer program is relatively new. It's a rigorous program which was piloted in China. We expect it to be rolled out globally via our member associations over time. It basically reflects our effort to assure owners that engineers with that certification have received by examination and/or training and experience education in the areas covered in the FIDIC body of knowledge, such as project management, contracts, procurement, and integrity. I should emphasize it's not a, quote, technical program. It's not related to how to design a water treatment plant or a bridge or that kind of thing. And in that connection, the only people eligible to even pursue that certification need to have graduated from a recognized engineering university. So you'll be hearing a lot more about that program in the future. And the next slide, please, Rachel. Switching to the next subject is FIDIC committees, which are also extremely important to us in an organization, and I'd submit probably any professional organization. And we have a lot of them. We have board level, geographic, and working or standing committees. We recently restructured them and created some new ones. The terms of reference of our committees are synchronized with each other, and our committees are staffed by a large group of diverse volunteers. We welcome experienced professionals, including the folks on the phone here or at Zoom, to let us know if they're interested in participating in a particular committee. And information on all our committees is, again, on our website. And there's a lot of them, and we're always interested in folks who are interested. So the next slide, please. So the last item I was going to talk about is our response to COVID-19. Immediately after COVID-19 hit us, we at FIDIC took very significant action by conducting 18 webinars and producing guidance documents. Next slide. Over 9,000 people from 150 countries participated. It's probably the largest group that we've ever communicated with last year. We had 79 executive level speakers, and so far over 10,000 individuals have viewed some of the webinars on YouTube, which is still available for those of you who may be interested in listening in on one of the webinars or two, or all of them. Next slide, please. The list of subjects covered is shown here and on the next slide. Note that we started with member association. Oh, I'm sorry, Rachel, if you could stay back for a sec. Note that we started with member association responses, followed by 5 webinars related to contracts, insurance, disputes, and claims. And that was an area where we had a lot of discussion. Participants were cautioned to seek the best solutions for claims and disputes for all stakeholders in this interesting time we're in, realizing that the best solution may well be the least of the worst options. And I'm sure many of you have heard that one before as a real challenge. Easy to say, not that easy to do. After that, we moved on to internal working issues. And that's all right, Rachel, you were right on that switch. So go, that's it, Rachel. Sorry to be following you up like this. But in addition to internal issues, we're talking about responses, communication, economic and funding issues coming out of COVID and how the pandemic has changed the world. So they were very interesting sessions. Each one was about an hour and a half. And I highly recommend you take a look at some of them, listening in on YouTube. Next slide, please. Guidance documents were, as I said, also produced, and we produced them on 3 very important subjects: contract issues, and working on-site and remotely, and business guidance for consulting engineering firms. They were rapidly developed. Some of them were presented at our webinars, and they all are available by visiting the FIDIC website. And I highly recommend, if you haven't looked them over, you may want to get out our website and order some of them. They're very, very well done. Next slide, please. And we're not finished with webinars. We will be conducting a webinar program or continuing it in 2021, and we're focusing on 6 that in the first 6 months of the year, focusing on health, the new normal, dispute challenges, cash flow, uncertainty, and contracts, and many others. For example, we have 9 webinars scheduled on our committees, and another one, series of 2 or 3 on the State of the World initiative we have that you mentioned, Bill, very quickly in the introduction, which I'm not going to get into today, but unless there's a question on it, I could really talk about it. But it's a huge initiative to us as well. And Rachel, the next slide, please. And we're heading towards the end of my remarks. We've learned a lot from COVID-19 programs. Some of the messages received are that we're in a new normal. The cost of COVID could be between $1 and $2 trillion, and I personally think that's low. There'll be increased emphasis on health and safety. We believe there'll be more use of drones, robotics, and IT systems for all elements of infrastructure. And I, for one, believe we're going to see even more modular construction because it can be done in a more controlled environment. As I said before, there are implications for contracts. Disputes and claims are going to be a huge challenge in my view, particularly in the municipal sector, when there's perhaps less ability to be flexible or very flexible. But I heard one speaker mention that with regard to disputes and claims, if possible, you want to be very careful about how much you push a contract obligation, even if you are 100% right. We have a term over here of holding people's feet to the fire. I don't know if it's recognized around the world or not, but it's a term I've heard a lot about. And I heard one of the speakers mention that if you hold someone's feet to the fire to enforce a contract too much, you may end up with burnt feet yourself. And I think it's a nice way to look at it. Communication and trust, to me, that is always key to a successful project. It's even more important now. We think we're going to see investment shifts, certainly in the area of health, perhaps in housing. And I, for one, as an environmental engineer, think and hope that we're going to see more emphasis on truly dealing with global warming and the challenges. Also, firms will be more likely to be planning for future disruptions, and collaboration, similar to communication and trust, will be more critical. And finally, no one is immune from the impacts of COVID-19. And then, Rachel, if you could just jump to the next slide, and then right after that, next slide, please. And I know I've sort of fed you with a fire hose over the last 10 or 15 minutes. I wanted to touch on the items that I think you'd most be interested in, but this slide indicates how you can get in touch with any of us at FIDIC if you have a specific issue you'd like to address. So with that, I hope I didn't take too long, Bill, but that completes my remarks. And now to Claudia, right?
Yes.
Well, thank you so much, Bill Barton. I'm just really honored to participate in the seminar that you've hosted. So appreciate that there's participants truly from all around the globe. And it was really smart to pair Bill Howard of FIDIC and me together, because FIDIC and the ICC have a very long history together. The FIDIC suite of contracts specifically refer to Icc Arbitration, and the ICC and FIDIC join forces every year to harness extensive experience in construction disputes to host conferences around the world each year to engage leading construction practitioners and Icc arbitration experts wherever they're based. So for those on this webinar who may be interested, that might be an interesting experience as well if you haven't already attended. So let me just give you a quick overview of the Icc International Court of Arbitration. The Icc is the trusted world leader in dispute resolution services for almost 100 years. We're not quite as old as FIDIC. We will have our centenary in 2023. The Icc has handled over 25,000 cases since it was established. And in 2020, there were 946 new cases. What are the essential features of Icc arbitration? Well, it is the only truly global arbitral institution, not aligned with any geography or subject to the shifting political winds. And although global in scope, the case management teams around the globe or otherwise structured as regional teams can address local needs. In other words, they're available in your time zone and available to understand the local cultural issues. The Icc just opened its 5th case management office in the Abu Dhabi global market, and it's going to administer cases in the Middle East and North Africa. And there are case management offices in Hong Kong, New York, Sao Paulo, and Singapore. The other key feature of the Icc is truly the quality case management by the Secretariat. I submit it's second to none. And the essence of the Icc process is that a draft award, before it can be issued to the parties, is scrutinized by what we call the Icc court to assure that the reasoning is set out and to avoid errors. So in other words, that is designed to increase the enforceability of the award, which also has the impact of increasing the trust in the process, even by the losing party. I do want to recommend for everyone on this webinar the Icc Commission report on construction arbitration that was last updated in 2019. And it really provides great tools and techniques for effective case management in construction arbitration. It talks about things to consider when selecting arbitrators, what should be thought through at the case management conference, whether issues should be bifurcated in other tools like preparing chronologies and key terms and document control. I just want to address quickly the concept that sometimes international arbitration, or specifically ICC, is a club, but the global breadth is really remarkable. The 2019 statistics really debunk any remaining myth of this exclusivity. Parties in ICC arbitration came from 147 countries. The arbitrators came from 89 countries. ICC arbitration seated in over 100 cities in 62 countries, and the choice of law covered the law of over 124 nation states. The awards are drafted in 12 languages, and the important piece for this group is that disputes within the construction and engineering sector generate the largest number of cases, combined with the energy sector account for approximately 40% of ICC arbitration. Now, you don't need to take my word for it. The Queen Mary survey of 2019 identified the ICC as the most frequently used arbitration for construction disputes, and that is consistent with the preferences and practices identified in previous non-sector specific surveys. So what makes the ICC so popular when thinking about one arbitral institution over another? It's really the reputation, the quality of the case administration, and the internationalism, which is given among the reasons. So the ICC launched new rules at the start of 2021, and there's been a lot written and a lot of webinars on the changes. I just want to highlight a couple that are relevant to the construction sector in particular. The first is a focus on efficiency. We have expedited procedures which provide for an award to be issued within 6 months for disputes now under $3 million. Before, the threshold was $2 million. There's also new provisions for multi-party and multi-contract disputes, and the ICC is really well known for its experience dealing with complex, high-value multi-party and multi-contract arbitrations, and that is particularly key in the construction sector. The changes are really designed to make the process more efficient. Tribunals can add additional parties in certain circumstances, and consolidation ensures, those provisions ensure foreseeability when consolidation will occur. Two other points just to mention briefly are that, and following up on Bill Howard's comments about disputes and construction in this pandemic, the ICC had issued a guidance note early in the pandemic indicating how provisions regarding hearings and in-person hearings could be interpreted, and the new rules make clear and eliminate any question that tribunals do have the power to hold virtual hearings over the objection of a party, but obviously consulting with the parties and considering all facts and circumstances. And lastly, I just want to mention the focus on transparency. The ICC has the discretion to communicate reasons for its decisions. That would be not talking about awards, but the administrative decisions focused on the constitution of the tribunal, such as challenges, consolidation, decisions on jurisdiction. And I truly believe that a focus on transparency is essential to the legitimacy of arbitration more broadly, which enhances parties' trust in the process, and that is essential to the culture of alternative dispute resolution. I want to wrap up by noting that I'm just so honored to have the opportunity to lead the ICC court. It has a century of experience, the ability to support parties with a range of services, particularly for large, complex cases in the construction sector, while still focused on reducing time and costs. So the challenge for the next centenary, the next 100 years, will not be to rest on past accomplishments, but to continue to focus on diversity, transparency, efficiency, new technologies, all to strengthen what I described as legitimacy of arbitration. And for the ICC to build on those connections, serve the needs of the parties as their preferred dispute resolution provider. And I look forward to talking with you and answering questions.
Fantastic, thanks. I'm going to ask Claudia and Bill a couple of questions of my own, just to sort of encourage the rest of you to participate. You can either put your question in the chat, and I've already got a couple, or you can just unmute and ask your question yourself. From my point of view, I'm quite happy for you to just ask the questions direct, but I'll start with Claudia. So I know that you haven't started as president yet, and I'm not wishing to ask you to give away your secrets or whatever is going to be your amazing opening address. But are you prepared to give us a little tiny glimpse of what you see for you?
Yes, absolutely. I think of my job in two key buckets. The first is that crucial moment when parties are thinking about drafting the dispute resolution clause, whether it's in-house counsel, working with outside counsel, or maybe it's the business teams. And they have to make that decision. Are they going to use Icc arbitration or some other arbitral institution's rules or some other process? What is going to make them say other institutions may be okay and legitimately acceptable choices, but we trust Icc in that crucial and difficult moment when a dispute arises? And the second category is thinking about the user's experience with Icc arbitration. In other words, their interactions with the Icc court, the Icc secretariat. We are, in essence, in the service industry. We serve the needs of our clients, which are the users of arbitration. And we have to make sure that we are exceeding their expectations every day, that we are responsive, that the parties have a clear understanding of the process. There is transparency, and they have predictability of the process.
I couldn't agree more. I think you're taking your last point. I think that we're all, and I pains always to remind people, is solicitors, attorneys, lawyers, we are all in the service industry. People can get far too up themselves. We all have a product to sell. We're all service industry, but certainly as lawyers, attorneys, we also have a higher obligation to the tribunal with which we are engaged. And I think you're quite right. The engagement of the ICC on a broader basis and serving that is going to be a challenge. Bill, you mentioned the golden principles. Of course, as a lawyer, I would never, ever dream of amending FIDIC. As a lawyer, I'm also lying because my lips are moving. But you'll need to unmute. But of those golden principles, which is your favorite and why?
Well, my personal background is interesting. I don't want to get into too much detail, but I've spent my entire career at Camp Dresser McKee, which became CDM, which is now CDM Smith, where we are an engineering and a construction company. And a lot of my career has been leading units. But in addition to that, I've been the chief technical officer and quality management officer. And in those roles, I've been involved in, fortunately, a few big claims and disputes that the firm has had. They sort of bubbled up to me if they were really kind of messy. So as a lead into that, the one that I think is the most important, or the one that means the most to me, is this dispute avoidance and arbitration group, which I think surfaced first in the 2017 documents. I think it's so important to have a mechanism on a project to get the disputes surfaced as fast as possible, because it increases the probability that they can be resolved without getting into a lot of very lengthy litigation. So I think that's the most important. But the other part of it, Bill, is they're all important. I can think of many instances where we've picked up a contract and read it, and it says it's a FIDIC contract, and it's just not. It just is not. The risk is totally unbalanced. The rewards are fouled up. The time periods are wrong. And I don't think people are trying to intentionally foul up things and doing it. They're just looking out for their own interest, which is very understandable. But the problem is when you unbalance risk, and when you put too much of a responsibility on parties that can't control it, you're almost creating a problem down the road. You might feel good about, oh boy, this project is less risky now than it was when I started looking at the FIDIC contract, and that might be good in the initial thinking, but in the end, you're taking an awful chance of major battles at the end. So all of them are important. I think that dispute avoidance is probably the magic word that I would have if I had to pick one.
Okay, I'm all for dispute avoidance, and can't quite sign up to the non-amendment of contracts. I can't lie anymore. Dispute avoidance, I totally get. I think from my point of view, I think the problem comes not necessarily with the amending, but I think poor drafting. I think I see so many contracts poorly drafted, right, and also where people haven't actually sat and discussed it. I think it's a crying shame that more contracts aren't sort of obliged to have a workshop when the contract's drafted to make sure both parties actually understand the thing that the lawyers in some distant room have agreed, right, between them, because it sometimes bears no relationship to what the project managers, engineers, and the people on site actually think they're going to be doing. Okay, so another question.
Bill, could I just pick up on what you said? Is one of the problems that I think has evolved in construction is that there are so many parties involved. It's so complex, it's so expensive, that I think the industry has a continuity problem. You mentioned about the attorneys being in another room, maybe doing something, and the procurement people are in another room doing something, and people negotiating, the fee are in another room doing something, and then all of that comes together, and then the project starts, and there's a different group of people trying to do that. And over my career, I've seen an evolution of that kind of process. Everyone trying to do the very best they can in their own area. But I think there's been silos that have built up, and that also creates a problem too.
Yeah, it does.
Once again, it's easy to state the problem. I don't have a solution to it.
Well, the solution is relatively easy. I've been lucky to work with a few American companies on pharmaceutical projects. The answer is you get everybody in a room, you get everybody to say what they're doing and why and when, and so people can't hide, and then you have a regular meeting of people to decide, actually, here's the amendments we're looking at. Project manager, finance directors, people, is this actually going to work? And can you take this risk? But I want to get bogged down on that.
Sure.
Ricardo's asked a question for you, Claudia. Now, Ricardo, it's a teaser. I think you're in Peru, but he's asked, do the ICC case management offices imply that disputes from a region tend to be handled by arbitrators from that region. And he's concerned about sort of a regional clique developing. And does that also then marginalize some areas and others? So, Claudia.
Terrific question. The ICC is premised on the parties selecting their own arbitrators in the first instance. So in a case where there are 3 arbitrators, the default rule is that each side picks their own arbitrator, subject to requirements of independence and impartiality and confirmation by the ICC court. And then if the parties don't reach agreement on the 3rd arbitrator, who serves as the president of the tribunal, then the ICC will appoint that arbitrator. So if the dispute is in Latin America, but one of the parties wants to have an arbitrator from Asia or the United States or from Europe, they are perfectly free to select any arbitrator they choose unless there's other restrictions in the contract. When the ICC does appoint arbitrators, it looks at really all of the factors in the case, including where the arbitration is seated, the governing law, and the parties of the arbitration. And most importantly, another element of ICC arbitration is that the sole arbitrator or the 3rd president arbitrator, who's the president of the tribunal, cannot be from the same nationality as any of the parties, and again, unless the parties otherwise agree. So I would say if the parties want to have dispute arbitrators from the region, they can, but I think the arbitration process under the ICC rules assures that there isn't that geographic or national bias.
There you have it, Ricardo. What a great great answer. Thank you, William. Bill, another question for you. What was your favourite development from the 2017 contract? So lots of questions for you about favourites. So.
Well, in the 2017 documents, I got personally very involved in it. And it took us a very long time to produce them, which is one of the reasons that the board, of which I was a member at the time, asked me to get involved in it to try to help move it along. I like the 2017 documents because they are incredibly thorough. They really get into a lot of information on procedures and that kind of thing. What if this happens, then do this? What if that happens, then do this? As a result of that, on a negative side, I've heard from some folks that they're just overwhelmingly long or too long. And my response to that is I've never been involved in a dispute when the dispute really got severe, where someone complained about the length of a contract. I think there's been a lot of disputes that many of us can relate to where the wording was ambiguous or not clear. And the other answer then to those 2017 documents, they are long. I agree with that, but they're designed for reasonably complex projects that are conducted globally by decently qualified engineers, etc. If the project is very simple, very straightforward, and one has a lot of confidence in the executors of the project, the engineer and the contractor, etc., then you're probably better off going with a thinner contract called the Green Book, which is what we're offering. So my answer to your question is, I think there's 4 contracts to consider: yellow, red, silver, which are the long ones, and then that green one, which you can come back to if the situation warrants. So probably a lot of different answers within that, but that's my reaction to it. So I was very heavily involved in it, extremely so.
Okay, and Claudia, what would you change if you could make a change to people presenting before a tribunal? From your experience, what's something that you would advise us all, say something not to do in presenting at a hearing, whether person or in Zoom?
Yeah, sure. We often hear that lawyers try to throw everything up against the wall and see what sticks. And so a piece of advice is often given to focus on the best arguments. I would like to refine that tip, in essence, to say that advocates should focus on the issues in dispute. In other words, what is it that the arbitrator has to decide? So sometimes that's also framed as making the arbitrator's job easier. But I think it's important to get granular, which is when the arbitrators draft their awards, they have to frame it and focus on, well, what is at issue here? What are the parties actually fighting about? What does party A say? What does party B say? And then what is it that I'm going to decide? And, when lawyers do appellate advocacy, they have to typically frame, in litigation, they have to frame what is the issue for the appellate court to decide. And I think that's the same and good way to frame everything in the arbitration. And I've seen great arbitrators prepare that list of issues, send it to the parties, have them refine it before the hearing ends. And that gets everybody focused on those issues if they haven't already done so.
Yeah, good advice. I was once told as well to, in drafting, remove sarcasm and all the sort of the slanging off and all that, slagging off, because it actually gets nobody anywhere. And focusing on the issues does exactly as you say, help you decide whether you've actually got the facts and information and documentary evidence to either back up your case or to find holes on the other side. Just looking, any more questions? I've got another question for Bill. What do you think are the challenges that actually to you both? But first to Bill and then to Claudia. What do you think the challenges are for your organisations, say over the next year? So a sort of a year as a short term, but then say over a 4-year period as a longer term.
We talk a lot about that at our board, and we've done a lot of things in the last, say, 3 or 4 or 5 years to address what we see are the challenges. Probably in the broadest sense is we have 100 members or member associations, and from different countries and different parts of the world, and they have incredibly diverse interests and requirements. For example, countries like the UK and the USA and Canada and France and Germany, I know I'm leaving some out, they operate routinely around the world, and they have lots of engineering construction programs. They're very mature, and their requirements are somewhat different from a developing country that's just sort of entering into the global engineering and construction stage of things. Now, I wouldn't call China a developing country. That would probably be wordsmithing, but I think it's a great example of a country that's now interested in working around the world with their engineering and construction expertise, similar to the countries I just mentioned. And they create some challenges as well. So it's the changing world and the diverse needs of our countries that really keep us awake, and the culture differences as well. Another example is that developing countries in say particularly in Africa, which have a lot of big environmental issues, and what we hear from them constantly is assistance to them in the area of capacity building, training, like that FIDIC consulting engineer program that I mentioned, training on project management and contracts and procurement, because they want, obviously, they want to do more and more of their own projects in their own country with some assistance from the other global firms. And so there's a lot of diverse interests all around the world. The other one that I think is a huge struggle with us is diversity and inclusion. When you look at a picture of our board of directors, most of them look like me with the same color hair and the same kind of age, and that is a problem. And we are doing everything we can imagine to fix that. And we intend to over the years. We actually have a goal with our 9 members of the board of directors to have 1/3 of them of a different gender by 2 or 3 years from now. I hope we meet that goal. We really have to, because people look at this and they say, oh my goodness, the visualization is not that great. But we are making progress in it. Referring back to that slide on committees, if you look down at the leaders of the committees, you'll see a lot more diversity. So diversity and the interests of the diverse interest of the countries who are members is probably our biggest challenge.
I just want to echo Bill Barton's comment about diversity. I consider that to be a top priority for me and for the ICC and for the international arbitration community globally. It's essential to what I was describing as the legitimacy of arbitration. We can't be in a world in which the decision makers of individual arbitrations, the decision makers of the arbitration institutions do not reflect the participants in international arbitration and in the world more generally. And this has to really be a multi-pronged approach. We have to be thinking about diversity broadly defined. There's been great focus in international arbitration on gender diversity, and great strides have been made, although we say great strides and the percentage of arbitrators who are women is still quite low compared to men. But diversity is so much more than that. We have to focus not just on geographic diversity, but race and ethnic diversity. We need to focus on LGBT diversity and differently abled diversity.
Yeah, I think that's very true, and I think that the question of diversity, I face this on some of the other boards, associations that I sit. It's also about outreach. It's about finding more ways of connecting with people, as Bill was talking about at the end of his slide, the ways in which you can communicate with FIDIC. It's finding ways in which you can actually make ICC, make FIDIC accessible to people in different places. And that in itself will generate diversity. And so it's very important that we all share that information as well. Because I don't think people say knowledge is power, and it may be in a negotiation of a contract, but actually the sharing of knowledge, and that's the purpose of this webinar, is really the most important thing, and putting those points and access to other people.
Bill, okay. Could I mention one other quick thing on diversity, which just get into my head? We formed in the last year or two a diversity and inclusion committee to really address this. And one of the nicest things about that committee that I like is there's a lot of them in it that are our future leaders. It's not people like me that are in the committee looking at the wall saying, boy, we got to do something about diversity. No, we got the people that really can do something about it. In fact, we had one of the interviewers from the committee is from Iran. And and she's been calling people like me all around the world to get ideas, and they're sharing it with each other. So I think there's a lot of hope, frankly.
I think there is. Sorry, Claudia.
I was just going to add an echo and build on what Bill is saying. The ideas for diversity, the focus on what to be done are coming from a lot of places where the innovation is happening, particularly with the younger generation. And so I really want to communicate that I want to hear what people's ideas are and what they want to see. And my virtual door is open in that regard if anyone wants to get in touch.
Great.
Well, that's fantastic. And my next comment doesn't really apply to you, Claudia. I suppose it could. Obviously, Bill, you're old. You're a bit older than me, perhaps. I think that one of the differences is that you actually recognise it. I think in times gone by, there have been people, as you say, white, middle-aged men, white hair, who have refused to accept the need for diversity. And I think the fact that under your sort of stewardship and also under Claudia's, that these opportunities are arising and people are being encouraged, I think, and people being told to believe that they can be leaders. That's something that I think isn't done enough within our industry. Young people actually being told that you can be this person up here. There is no effective glass ceiling. I'm really grateful to Bill and Claudia. I hope everyone's enjoyed it. I certainly have. And I think we've had some very good questions. Everyone connected with construction and engineering, I think, should be looking forward to 2021 as an opportunity and with a positive outlook. So with apologies to Amanda Gorman for mashing her very beautiful poem, I would like to repeat a few of the lines from it because I think it's actually very inspiring. And this isn't the poem, okay? So you need to actually find these bits, so apologies again. We are far from polished, far from pristine. We will rebuild, reconcile and recover. The new dawn blooms as we're free of it, for there is always light. If only we're brave enough to see it, if only we're brave enough to be it. And in